No, the ones that were close to us were sold out of those boxes.
All right, I think we're going to get started. Hello, everybody. My name is Benjamin Sanchez. I'm your Texas consumer attorney. And we have members of my team here. This is a new series that we're going to be doing, and this is day one of the first edition of our consumer series. Today, we're going to be talking about unfair debt collection practices. That's something that a lot of people have to deal with, so I thought that was an appropriate topic to start out with. We're both in person and online via Zoom, so I welcome everybody online as well. We already have the next two editions or episodes planned. What we have is on November 11th, we have consumer auto fraud. And then on December 9th, we have landlord tenant. So every second Saturday, we will be doing some sort of seminar to help consumers with the type of laws and practice areas that we handle. If you have any questions or you want to get a hold of us and talk to one of our intake specialists, our number is 713-780-7745. So let's get started with debt collection practices. Now, first of all, what I need to let you know is that there are both state and federal laws that help you with debt collection. We have Texas Debt Collection Act, and then we have the Fair Debt Collection Practices Act, which is a federal act. So that is otherwise known as the FDCPA. Many people confuse that with federal, but it's actually fair. So while we say, when we talk about unfair debt collection practices, we're not talking about just violations of the federal law, but we're also talking about violations of the state law. Most states do model their state law after the federal law. What is a debt collector? So a debt collector is anybody that is not the original creditor who tries to go after you for debt. So a lot of people think that, well, the attorney represents the main creditor, so they're protected. No, the attorney is not employed by the debt collector, by the company that's suing you or going after you for the debt. So they are considered a debt collector. If you have an internal attorney, so you have an attorney that actually works for, let's say, Bank of America, then that attorney is not considered a debt collector. But if Bank of America hires another attorney outside of Bank of America to sue or to go after your debt, or they hire a debt collection company to go after your debt, then they are considered a debt collector, and then they are subject to the debt collection laws. It's very important to know the difference because not everything that we have applies to the original creditor. The original creditor has rights that go beyond what the debt collectors can do. Well, what are some of the limits here that a debt collector cannot do? First of all, we should talk about time and place limits. Generally, the debt collectors are not allowed to call you early in the morning and late in the evening. But what does that mean? The law says generally between 8 a.m. and 9 p.m., the debt collector is allowed to call you. But if they're calling you at 7 or 6 in the morning or at 10 or 11 at night, then that is considered a violation of the law. They also are not allowed to contact you at places they know you don't reside. The whole point of debt collectors calling other people and contacting third parties generally is not to harass them. The law says the debt collectors can't harass you by reaching out to other people you know. The only reason they can reach out to other people you know is if they don't know where you are. So they can talk to your employer, they can talk to your family, they can talk to your friends, but only to find out your information, okay? Most unscrupulous debt collectors obviously like to harass your family and friends just to get you motivated to deal with the debt and potentially pay them. But the law says that the only contact that are allowed with other people is to find out where you're at. So generally, I tell people it's best if you actually communicate with the debt collector and you tell them where you're at and you tell them to stop talking or contacting other people. Because once they know where you're at, then anything they do afterwards could be considered a violation of the law and thus allow you to have a claim against them for unfair debt collection practices. They're also not to talk to your employer if they know that your employer doesn't allow those type of calls. So again, most people, what they do is they hide from debt collectors because they don't want to talk to them because they're scared of them. But all that does is give the debt collector more power because now there's no one stopping them from making all these harassing calls and communications. So once you tell them, don't call my employer because those calls are not allowed. This is where I'm at. This is my phone number. This is my address. Then you cut off a lot of power from the debt collectors because now they can't go harass everybody else. They may try to harass you, but at least they're not harassing everybody else. So it's very important that you communicate with them. Additionally, let's talk about social media. So debt collectors are not allowed to post on social media about your business with the debt or the debt collectors. You know, they can't go into your Facebook feed and all of a sudden say, hey, you owe me money, or you owe my client money, when are you going to pay? Right? They're not supposed to publicly embarrass you or harass you like that. So they can't go onto your social media and do that. Can they contact you through social media? Well, they can, unless you tell them not to. Remember, the whole point of the contact laws, the communication laws in debt collection laws, is to be able to get a hold of you. As long as they have a good way of getting hold of you, then you can stop them from doing other things. So if you give them your address and your phone number and you say, this is the only way to contact me, then they can't use social media to contact you. They can't use friends or family or employer or anything else. They contact you some other way, let's say through text or email or whatever, you are allowed to tell them, don't contact me that way. The law actually says that if you tell a debt collector in writing and you have proof of it, that you only want to be communicated through mail, and that generally you want them to stop communicating with you. And if they do so, only do so through mail, they have to honor that. Okay, so if they're calling you, a lot of people will say, don't call me anymore, right? But most of the time, that's not proof enough that you told them to do that. So I always advise my clients, I always advise the public to put it in writing that they are to no longer contact you by phone, and then get that way that you have proof that they received it. Now, a lot of debt collectors are very tricky. They know what the law is. And so when they're on the phone with you and you start asking for their contact information, they refuse to give it to you. They will not give you an address. They will not give you an email address, whatever. So they want to avoid actually receiving anything from you in writing so that they can say that they never got these written requests from you to stop communicating with you in a certain way. At that point, it's best to at least try to record a call. If your phone has a recording feature, then go ahead and record that call. In Texas, at least, it is possible and legal for someone to record a conversation as long as they are part of the conversation. So I cannot record someone else's conversation, but if I'm in a conversation, whether in person, on the phone, or whatever, I'm allowed to record the conversation. So a lot of phones these days have the ability to record a call, record that call with your admonition that they do not contact you or, all that kind of stuff. That it will be approved if you ever have to have a trial or claim or whatever. If you don't have that ability on your phone, then put them on speaker and just record the conversation some other way. And if it's not directly on your phone, do that some other way. But the best thing is if you can get it in writing and send it to them via certified mail. That way you'd have proof that they received it in writing. But if they refuse to give you the contact information, then at the very least, you should be recording that phone call. And again, they're not entitled to contact you by phone forever and ever just because they are trying to collect a debt. You can tell them to not contact you by phone at all, not contact your friends or family or employer, but you can tell them, do not contact me by phone at all, only contact me in writing. When the law says you have that right, and they have to abide by that. Now, whether they abide by that or not is another story, but you can tell them, only contact me by mail. This is my mailing address. There you go. An attorney, a debt collector is not supposed to contact you if they know that you are represented by an attorney. What some people do is they try to fool the debt collector and they say, hey, I have an attorney. The problem is that the law doesn't say, well, if you just utter those words, they're not supposed to contact you. The law says if you are actually represented by an attorney and you let the debt collector know about it, then the debt collector must not contact you any further. So what does that mean? You have to have an actual name, address, and phone number for the attorney somehow so you can identify the attorney who's representing you. Whenever we are hired to do debt defense, we always send out what we call an initial letter of representation. And in the very first paragraph, we tell the other side, we've been retained by Joe Blow and do not contact him any further because he's now represented by counsel. That's the very first thing we do. But we're an actual law firm. If you are a debtor and you're trying to get out of it, don't take the cheap way out and try to, create some law firm letterhead. Don't try to tell someone you're represented by an attorney when you're not. If you're looking for an attorney, you are not represented by an attorney. Okay, there's a difference between I'm going to find an attorney to represent me, and I already have an attorney that's going to represent me. If you tell a debt collector that you have an attorney, you must actually have the attorney and be best to give that debt collector the information so that if later there's a claim, you can say, not only did I tell them I had an attorney to stop contacting me, I gave the name and identifying information so that they could contact the attorney directly. So I think that covers pretty much when and how a debt collector can contact you. Okay, so they have to contact you where you want them to, as long as you give them the appropriate address. They can't contact other people as long as you're communicating with them and they know where you're at. Let's talk about now what kind of debts are covered under these debt collection laws, because those debt collection laws generally apply to personal, family, and household debts. In other words, if you are a small business, you're not necessarily protected under these debt collection laws. There is an exception, and we'll get into that because Texas law is a little bit different than federal, but generally under the federal law, commercial debt is not considered part of the protections you get. And that's generally the case in most laws throughout the United States. They treat individuals and residential matters different than commercial matters. For example, here in Texas, we have the Texas Property Code, that primarily applies to residential leases, not commercial leases, okay? So just know that. If the debt is in your name, but it is a commercial debt, it is still considered a commercial debt. So if you want to make sure that you are protected, it's best to actually put that debt in a commercial name. If you're doing business, you should at least have a DBA and then use that name whenever you're engaging in the purchase or lease of goods. There are going to be cases where people will fight about whether or not a debt is commercial or not, because it will be in someone's individual name, but it will be obvious it's a commercial debt, right? If I go purchase manufactured piping for my company, to deliver to a customer, but it's in my name, it's very likely that that manufactured piping is not for personal, family, or household use. So though in that case, that debt would not be part of what's covered under these debt collection laws. Well, what are considered personal, family, and household debts? So things related to the purchase of a house, purchase of an automobile, renting a house, leasing a house or apartment, just basically leasing finding your residence, medical care, just regular debt like credit cards, personal loans, all those kind of things. So anything that have to do with your person, your family, and grocery stores, all sorts of things are covered under personal, family, and household debts. The main thing is just to know what I like to tell people is instead of trying to figure out what's covered in the personal, family, and household, do the opposite. Just figure out if this is a commercial debt or not. If it's not a commercial, then generally it's going to be personal, family, or household debt. We are, at least on the Zoom and later, we are going to take some questions. So I'm not going to take the entire hour to just give you a lecture. So if you're on Zoom and you want to, we have someone monitoring the chat, you can put some questions in the chat, and then if we're in person, we'll save some time later to ask questions. This initial seminar is not meant to go into every single detail of all debt collection laws. Because we only have an hour, we have to sort of stay high level. But these are things that I teach other attorneys about. These are things I could go on and on about in terms of the minutia of the law and the details of the law. This is to try to give you a general overview so that you're educated and have a better knowledge about what to do and what not to do when you're faced with these situations. As I mentioned before, a debt collector is anybody who's doing contacting you for debt owed by someone else. So you owe someone else the debt, and then someone else who's not the person you owe is contacting you. And that's considered a debt collector. In Texas, these debt collectors are called third-party debt collectors, and there's a requirement that they have a bond. So they must have a $10,000 bond in case there are claims that this debt collector violates the law. There's some sort of remedy you can potentially collect on the bond. So there is some protection. Them not having a bond is also considered a violation of the Texas Debt Collection Act. So if you can find out the true name or of the company that's doing the debt collection, you have the ability to go online in Texas and figure out if this debt collector has a bond. And if they don't, they should not be collecting in Texas. They should not be allowed to collect in Texas. And that in and of itself could be a violation of the law. One of the things I do want to say as we go through this is that most people get really scared when dealing with debt collectors. So they either hide, or if they do talk to a debt collector, they basically let the debt collector run the communication. And before they know it, they're agreeing to make payments or acknowledging that they owe the debt, or those kind of things. You have to understand there are competing interests when you're dealing with the debt collector. A debt collector is trying to collect money from you, but you are trying to collect information. They want money, you want information. If you consider yourself like a reporter interviewing someone, that should be your role as far as the debt collector. Who are you? What debt do you collect? What debt are you trying to collect? Who do you represent? How old is this debt? Give me some information about this debt so I can verify the debt. Most debt collectors don't want to go through all that. They just want to beat you over the head and they want to scare you into agreeing to settle with them and make some money. Why is that important? Because some of the debt that they're trying to collect is too old to actually sue you on. Now let's get into that really quick. There's a difference between the ability to sue on a debt and the ability to collect on a debt. A debt in and of itself never goes away until it's paid. There's a common misconception that people say, well, this debt is too old to collect on. That is not true. You can go all the way until you die, and that debt could still be there, and there could be a claim against the estate. That debt could still be there. What they can't do is they can't sue you after a certain amount of time. That's called the statute of limitations. And in Texas, it's 4 years. So they can't sue you after 4 years on a debt. That doesn't mean that in years 5, 6, 10, or 20, that they still can't contact you about the debt and try to collect from it. So when you, the issue is that if the debt is too old to sue on, but then you end up acknowledging the debt and making some sort of payment towards the debt, the law says that that 4-year limitation time restarts. So you will find that a lot of debt collectors, they want something, right? They all they want is some sort of payment. The law doesn't say it has to be a certain percentage. So even if you pay $10 or $100 on a debt that's a few $1,000s, you have now re-triggered the statute of limitations, and now they get to sue you within the next 4 years after that. So you want to make sure that you have a clear head and that you can focus on these calls, because they will try to do things and you will just want to get information without agreeing to anything. Don't deal with the debt collector when you're driving. Don't deal with the debt collector when you're in the middle of a family dinner or a family function or anything else, because you need to be clear-headed so that you can respond objectively to whatever the debt collector is trying to do to you, rather than you being already in a stressful situation and them just making you more stressed. Because debt collectors, at least the ones who are bad, they love to harass and trick you into agreeing to something. You don't want to agree that you owe the debt. You just want to find out what the debt is. You want to find out how old the debt is. You don't want to agree to make a payment. You know, they may say, well, I'm going to keep calling you until you pay me. Okay. That in itself is illegal too. They cannot repeatedly call you. We hear some reports of debt collectors just repeatedly calling debtors over and over and over again. Can they call you multiple times in a day? Oh, well, yes, they can. But can they do it to the point of harassment where they're just not letting your phone, you got to put your phone off a hook or whatever? They can't do that. Okay. So unless you're ready to be mentally clear when you're talking to them, I advise not talking to them at that point. But when you do talk to them, your function is to gain information. You understand what their function is. Once you understand that their function is to collect, you don't have to be so nervous about it, because most people avoid the phone call because they don't know what to expect. They don't know what's going to happen. But if you know what's going to happen, then you should be able to take the call. You know that you're not going to agree to whatever the debt is. You know that you're not going to agree to a payment. You know that your job is to ask for information. Everything that we learned in school for those basic questions, who, what, when, where, why, and how, those are nice questions to ask the debt collector. And you're probably going to piss most of them off because they don't want to be the ones answering questions. They don't want to give you information. They just want, their job is to get you to agree to something so that they can then either get paid or has the ability to sue you. We had one particular client last year who was being harassed. His work was being called, his family was being called. This debt collector kept calling. It was an individual loan. And unfortunately, at least in the beginning, the person who was owed the money, was the one harassing. So you understand they're an original creditor, and so they could bypass some of that. But then I guess he got tired of doing it himself, so then he enlisted other people. And once he did that, whether it was an attorney or other associates, because this was a personal loan, not a business loan, all those people were debt collectors. So when our client hired us, we were able to make sure that they understood that our client was represented by an attorney, and all the shenanigans that was happening had to be stopped. I had to let their attorney know, hey, your client needs to stop all this. And he wasn't happy. In fact, the creditor still tried to do some direct harassment, but I think his attorney told him, he needed to think about that because he violated the law. So eventually I was able to deal with the attorney and we were able to work it out. But those are the kind of things that we help clients deal with. A lot of clients come to us not because they're prepared to actually pay the debt, but they just need somebody to protect them from the harassing debt collectors. So what I like to say is that we're sort of the middleman. You have a creditor or a debt collector here, and you're here. And right now the debt collector has full access to you. They can do whatever they want because they got full access to you. We get in the middle so that all that stuff comes to us. But guess what? My team and I, we're prepared to handle it. We have people who answer the phones. We have attorneys, we have paralegals and legal assistants. We can handle all the debt collectors. And guess what? The debt collectors don't harass us because they know better. So quite frankly, all that bad behavior that was going to you doesn't necessarily just all come to us. Once we get in it, 90% of the time, that bad behavior stops because now they know, well, they're dealing with an attorney and it's just not going to be the same. I'm not saying you have to have an attorney to deal with debt collectors, but it certainly helps. And just so it's clear, when I told you earlier that when a debt collector is trying to collect, they can call other people, contact other people. But what can they contact them about? They can contact them about where you live, what your phone number is. Again, basically your contact information, and potentially where you work. They're not allowed to keep contacting third parties, so they can contact them once. So let's say that they find a number for your aunt, and they call your aunt, and they get a hold of her, and whatever is the result of that conversation, that's it. That's the only time they can contact your aunt by law. Now, if they contact your aunt and it goes to voicemail, they can keep contacting your aunt until she answers and actually get a hold of her. But once they get a hold of her, it's a one and done rule. But they can contact your aunt, they can contact your father, your grandmother, whatever, until they get information. Now, once they got the correct information, they still can't keep contacting other people. So if your aunt happens to give them information that they can verify, because then they use that information to contact you and get a hold of you, then they're not allowed to call everybody else because they already know where you're at now. They already have your contact information. It's not nice to have to deal with family, friends, and employers, letting them know that some bad debt collector is trying to contact you. But if you do have to let people know, I would say that the best thing to do is to actually just go ahead and authorize them to give that information. If you know who the debt collector is and you can contact them yourself, then you do it. But if you don't know that, and you just know that they're coming in, but you have no way of getting the information because they're calling from an unknown number and they're not giving you the information, just let the people who are telling you they're being harassed, hey, just go ahead and give them my information. Because once you give them the information, they have a duty to not call you anymore. If you just keep trying to hide, they'll keep bothering people. A lot of people think that the debt collectors, all they have to do is call you, but that's not true. If the first communication is a call about a debt, then within 5 days of that call, they have to send you information in writing. Okay, the law says that they don't get to just tell you everything about the debt all by phone. If they're able to get a hold of you, then within 5 days of getting in contact with you, they have to send a notice to you through the mail. What does that notice have to tell you? It has to tell you how much you owe, who's the name of the creditor that you owe, and what action to take if you believe you don't owe the information. So if you've ever seen a typical debt collector demand letter, it's going to say, we are a debt collector, we're attempting to collect the debt, and any information will be used for that purpose. That language is actually prescribed by the Fair Debt Collection Practices Act by federal law. And then, Texas just says they also have to say, in addition to that we are a debt collector. So basically, if they're collecting in Texas, they have to say, we're a debt collector, we're attempting to collect the debt. Any information will be used for that purpose. And then they have to give you that information that said, if you dispute the debt or want verification of the debt, and I'm just summarizing here, you got 30 days to send them that request in writing, and then they have to stop their collection attempts during that period that they need to give you that information back. That information sometimes takes a while. Sometimes they already have some form letter they could send right back to you because they want to get right back to collecting. But if you get a successful call where they contact you and they don't send you that written notice, then again, that is an unfair debt collection practice and that violates the law. They have to send that to you. Now, if they do send, if the letter goes out to you, or that's the first thing they do, it doesn't mean they can't call you, right? They can do both, but they must send you the letter if the first attempt contact with you is by phone. But if they send you a letter and then they follow up by phone, that is perfectly fine. We have questions about, if you say you don't owe the money, can the debt collector still contact you? Well, again, you have to let them know in writing that you dispute the debt and that you want verification of the debt. Sometimes it's called validation, verification, but basically they're required to give you, again, the name of the original creditor and how much you owe, what this debt is about. Are they required when they dispute the debt to give you all the invoices and everything? No. A lot of times what I see a verification is just some one-page letter that says, pursuant to your dispute and your request for verification, here's the information that we're required to provide you by law, and they give you the name of the original creditor, how much you owe. I kind of want to give you just a general list. I think in the future we will do some deep dives on particular behavior by debt collectors. But let's go over some of the debt collector practices that are illegal. Such practices include harassment, false statements, and other such practices. So let's talk about harassment for a few minutes. So harassments, debt collectors may not harass you, they may not oppress you or abuse you or any of the third parties they contact, in trying to collect that debt. So they can't use threats of violence or harm, they can't threat that they're going to publish you on a list, people who refuse to pay their debts. They can only do that to credit bureaus, right? They can legally report to a credit bureau that you're not paying your debt, but they can't just say, oh, we're going to publish in the paper that, that you're a deadbeat, or go on social media and say that you're a deadbeat. they're technically, I mean, legally, they're not supposed to use obscene or profane language, but you get an aggressive debt collector and you have all sorts of things that come out of their mouths. They also can't use the telephone to annoy you. So as I said before, they can't repeatedly call you and call you and call you. What does repeatedly call you mean? Now, sometimes the law has to take the situation as it comes. Is if someone is picking up the phone and calling you right after you hang up, we know that's repeatedly calling you. But let's say they're calling you every 5 minutes for 2 hours. But that's probably, enough to say that's repeatedly calling you. I would say if they call 3 or 4 times a day, that's probably not going to be repeatedly calling you as long as they're not doing it in a row. If you are having some sort of emergency, you actually let the debt collector know, hey, I'm in the middle of giving childbirth, or I'm at the hospital with my mom who's in surgery or whatever, right? And they repeatedly calling you, they know the situation, and now they're intending to harass you, right, and abuse you because they know the situation. So harassment is a big deal. They're not supposed to harass you. What also can't they do? They can't lie to you, and they can't misrepresent things to you. They can't, lie about who the creditor is. They can't lie about how much you owe. They don't have to give you, at least on the phone, how much of that is the underlying debt versus how much their cut is, right? So a lot of debt collectors work on a contingency, so they mark up the debt with their fee or their contingency so that they're trying to collect the whole thing and not just the underlying debt. And so, if they, most of the debt collectors won't answer this question, but again, you're a reporter. If you ask how much of this debt is owed to the original company versus how much are you trying to collect on your behalf for your fees, they can't lie about that if they answer that question. Most people will just avoid that question. They'll just say, well, the total amount is, but let's say that you owe $5,000 and their cut is $1,500. They can't say that the full $6,500 is owed to the original creditor, right? Because the original creditor's debt is really only $5,000 and their cut is $1,500. So they can't lie about the amount of the debt. They also can't lie about who they are or what their authority is. We've had a lot of people, especially in our Spanish-speaking community, where the debt collectors, basically tries to say that they're attorneys, they're law enforcement officers, or that they're government officials, they're from the court or whatever. How many people have received calls where they threaten, we got someone down the street who's ready to take you to jail. We got someone down the street who's ready to serve you with this lawsuit if you don't pay us right away. And, they can't threaten you with jail, at least for not paying the debt, right? Can people go to jail for debt? Not directly. So in the United States, we don't have a debtor's prison like they used to have in England before our country was started. One of the reasons our founding fathers want to get away from England, among many, was the fact that you could go to jail for being poor because you couldn't pay your debts. That doesn't happen in the United States. Now, if in the course of collection, there ends up being something that you don't cooperate with, can the court put you in jail for that? Yes. So let's say you're in a debt collection lawsuit and you're ordered to turn over something that maybe is at the center of the debt dispute, or you're ordered to enter discovery and you don't do that. Could the court eventually find you in contempt of a court order and then send you to jail? Yes, right. But that jail is not, you're not going to jail for the debt, you're going to jail for the behavior. And I will get through, let me go through just a few more and then we'll open it up to questions. They can't say that you've committed a crime. Remember, not paying a debt is not necessarily a crime. If you defrauded someone, right, then that's something else. But just simply not being able to pay a debt in and of itself is not a crime. a lot of people will again say that you're going to be arrested, that they're going to seize certain things or whatever that they have no power to do. Okay, in Texas at least, if there is a debt judgment, someone could potentially eventually garnish your bank account. Okay, so that is possible, right? And a debt collector can tell you that this potentially could lead to the garnishment of your account. But what they leave out is all the steps they have to do to get to that, right? They just say your accounts, will be garnished or whatever, right? But they have to, they have to file the lawsuit. They have to eventually get a judgment. They got to figure out where your money is. That judgment has to be good, and all sorts of stuff. And then in Texas, they're not supposed to take, your Social Security, retirement, and disability, things like that. The problem is that no one knows what that account is, generally, what money's in that account, so that they can freeze it right away, and then you can try to undo it. And we could do a deep dive on bank garnishments some other day, but they can tell you that eventually that can happen, but they can't just say, okay, well, if you don't pay, we're going to garnish your bank account tomorrow. Don't confirm with the debt collectors any personal information. They say, well, we have your bank account information. We just need you to identify it. So we're pulling the money from the right account. Don't go, okay, give them your bank account information. Don't give them your birthday, your social security number. If they're really collecting that, they're supposed to have all that. You can give them your name, your address, and your phone number. They also can't, again, we talked before about how long they can take to sue you. So after those 4 years in Texas, they can't threaten to sue you if it's in fine print. But they do have to say, when they're trying to collect a debt that's more than 4 years old, in writing, they'll usually say, this will not result in a lawsuit. We're trying to collect a debt, but they'll use some language to let you know that they understand that they can't sue you on this debt. So, but we have lots of debt collectors who threaten a lawsuit when the debt is more than 4 years old. I think sometimes we get people who want to argue with the debt collectors about things, and just because we're giving you this information, we're giving it to you for defensive purposes, not for offensive purposes, because you think you're going to win a battle, argument with a debt collector. All debt collectors, they're going to talk to people all day long. So whether they're talking to you or someone else, they don't care. So you're not going to out argue them, right? This is not going to, oh, well, okay, you beat me. I'm going to go away now. They can't falsely report your debt to the credit bureau. That's another unfair debt collection act practice, is they can't give false information. Now, giving false information to a credit bureau would also violate the Fair Credit Reporting Act, which is another federal law regarding the separate issue of what can be reported to a credit bureau. I know this is sort of there's a lot of things within what I'm telling you that we can do a deep dive on. I'm trying to give you the highlights so that you understand some of your rights. Well, they can't threaten to seize your property when they don't have the right to, or that property is not subject to seizure. So, for example, some debts are what we call secured debts. When you buy a car, the bank's note is secured by the car. That's why we have repossession. Okay, when you have a mortgage on a home, the home is a security for the mortgage. That's why they can do a foreclosure on their lien. But to the extent that they don't have those rights, it's illegal for them to say that they do, or that they will go do something. Okay. In Texas, we have non-exempt property. We have a homestead that's exempted from collection. We have, each adult is entitled to one vehicle. You're entitled to so much personal property and money to be protected from debt collectors. If you would tell a debt collector that all you got is a home and one car, they can't come and tell you, well, we're going to take your home, we're going to take your car, because legally they can't do that because those are exempt. But if they know you have a rental home, or they know you have more than one vehicle, then they can threaten that they could potentially take the rental home or the additional vehicles. And it's a one vehicle per adult. So if you're with someone, if you have a spouse and you have two vehicles, you're still okay, because each adult is entitled to a vehicle. Now, each adult is not entitled to a home just because they're an adult, right? So if you are married, unless you're living apart separately and declared separate homesteads, you don't get to say, well, the husband's home is the homestead, where you live, and the wife's homestead is the rental home. That doesn't work. They can't make collect calls without identifying who they really are. They can't lie about who they are. So they can't say, well, this is, the manager from the local grocery store, we saw that you left your wallet, you accept the charges, and then all of a sudden it turns out to be a debt collector. Now, we don't really deal with collect calls anymore because pretty much phones are ubiquitous, but that's still another thing that they can't do. And I'll just end with a list. Some of it may be familiar. So they can't use a false name or identification. They can't misrepresent the amount of the debt or judicial status. They can't tell you there's a lawsuit on a debt when there isn't. They can't tell you there's a judgment when there isn't. So they can't lie about the nature of the legal status of the debt. They can't send documents to you that appear to be from a court or some government agency when they're not. You'd be surprised at the kind of seals that we see on debt collectors' letter, or the general kind of name. You'll look something look like a government name with some sort of seal, and even though if you really look at it, it's not. It's not from a government. It appears to be from a government, so they can't disguise their debt collection letters like that. They also can't lie about who holds the debt. So if you have a Bank of America debt that's now being held by a debt buyer, they can't say the Bank of America has the debt. The Bank of America no longer has it. It's important because you may decide certain actions based upon who has the debt. We know that debt buyers buy debts really cheap. So you may not want to agree to pay full value on a debt buyer's claim, whereas you might think about it on an original creditor's claim. They can't also, they're not supposed to lie about what information they have in order to trick you into giving them payment or other information. That's kind of a really broad thing, but debt collectors sometimes will say that they have certain things, they have certain information, and they're going to take action on something when they really don't. We've had our clients had calls from Washington, D.C. area code numbers with people saying, oh, we're in court, but we talked to the judge is going to allow us to do this, but you got to do that. All of that is fake. They can't collect more than the amount that you originally agreed to pay, but there can be collection fees, there can be attorney's fees, there can be interest. Okay, but if your original principal amount was $5,000 and you only paid $1,000, so now you owe $4,000, at least on the original principal, you may owe a lot more than that because of all the other stuff. But they can't come back and now say you owe $5,000 with the original principal because you actually paid $1,000 of that down. So you can't really do that. With that said, are there any questions? Let's start with Zoom first. Any questions on Zoom?
Yes, we do have a few. We have a question of what if they call you at work? You tell them that you are at work and to please not call. However, they continue to do so, and sometimes they get sneaky and say they are from a different company. However, they are really calling for the same situation as they did the first time they called.
So again, they're not supposed to call you at work once you tell them not to call you at work. And they're not supposed to lie about who they are. Now, debts are often sold, so it's possible that you know, 1 week, 1 month, you can have one debt collector. Then all of a sudden you have a different debt collector. So you have a different company, it's about the same debt. The laws apply to each new debt collector. So unfortunately, the subsequent debt collector may or may not have information, right? It depends upon how good the file is from the prior debt collector. So the law says we're not expecting the new debt collector to automatically know what the old collector was told of their information, right? So you have to do this all over again for each new debt collector. But once you let that new debt collector know they're not supposed to call you, they're not supposed to call you. Now, the thing is that when people do say they don't call me at work, and if they're calling you, let's say they're calling you your work number, because that's the only number they have, and you tell them don't call me at work, unless you give them a different number for them not, to call you, or you give them an address for them to email you. You can say altogether, don't call me at all. Here's my mailing address. Anything you want, you need to mail it to me. That is perfectly fine. But you can't just say, don't call me at work, and then they don't have anything else to go on, because that's the only way they can contact you. So the idea is to redirect their focus to where they're just dealing with you directly. Do you have any questions before we get to another question?
Me?
Yeah.
No, not really, but I just think if there is a federal law and then there is a state law. So which law supersedes and the judge has how he comes to the conclusion that the federal law supersedes or the state law supersedes.
So we have a question in our audience about the fact that we have a state and federal law. And so which law supersedes the other one, and judge is trying to make a decision. Luckily, the laws are very similar, but when we bring defenses in debt cases, or we bring affirmative unfair debt collection practices lawsuits against the debt collectors, a violation of, you can have multiple violations. So we can say you violated this law, Texas law, by doing this. That violation is also a violation of federal law. So we're suing you under both laws. Or you could have something that violates just Texas, and you can just say, well, for this particular action, the debt collector violated this law. So not necessarily that law. So they're not really competing in the sense that you have to choose one or the other. Some debt collection behavior may violate both laws, or may violate one or the other, and you're free to use both laws or one or the other. Okay. And next question on Zoom.
Yes, and I think you kind of covered it, but can you ask them to mail you a copy of the original debt that is due?
So the law doesn't say that they have to mail you the original contract. They don't have to mail you the invoices and all that kind of stuff. The law says is that you can dispute it and ask for verification, but the verification, unfortunately, is very limited, right? They have to tell you who the original creditor is and how much you owe, basically. So again, even as an attorney, when I dispute a debt, I can't just ask for all the underlying information. I can ask for it, but they don't have to provide it. Normally, that kind of information won't be required to be produced unless there's a lawsuit. So in lawsuits, we have what we call discovery. We can ask for documents, we can ask questions, those kind of things. And in the discovery process within the lawsuit, we can ask if the other side has the original contract or whatever. Now, just because they don't have it doesn't mean they can't try to collect on it, right? That just goes to whether or not they can prove their debt. So a lot of times when we battle debt buyers or debt collectors, they don't have the original contract that you signed, right? It's all electronic. They have terms and agreements. They have a database of information they collected on the phone, but they're not ever going to produce the actual contract. You don't win just because they can't produce some credit card agreement. It's funny that a lot of people still ask for, I want the original credit card agreement I signed. Well, when's the last time you ever signed a credit card agreement? Like you don't sign credit card agreements these days. All of it is done either on the internet or by phone. So they're not going to have something that you sign, and should know that you're not going to have a signed agreement with them unless this is just an old credit card. So they're not required to actually produce the actual contract. They just have to verify who the original creditor is. Anything else?
Yes, I do have a couple more questions. What can a person do if they get a judgment against them, but they were never served with a lawsuit?
We deal with this all the time. We have a few cases like this right now. There's something called the bill of review in Texas. You have up to 4 years to bring a bill of review. A bill of review is basically a new lawsuit that you file in the same court, and you ask the judge to overturn the lawsuit, the judgment, because you were never served and never knew about the original judgment. Now that's a little bit tricky because you can't just say, well, I wasn't ever served, because normally you like to have some proof of it. Now, some of our clients don't have proof, and we'll fight it the best we can. These days, at least in Texas, the court clerks are required to give you written notice of a judgment within 20 days of the judgment being signed. Now, that written notice can only go to the address that's been provided by the creditor, by the debt collector or the debt collector's attorney. So sometimes, even though the clerk has sent out that notice, you don't get it because it's a bad address to begin with. But just because you weren't served doesn't mean that you're free, because if you were served, if you were not served with the lawsuit, they get a judgment, but then you get the clerk's notice. Okay, then you still have a duty to act. And if you don't act when you got the notice, then you consider to waive that issue. But we do deal with bills of review. If we're successful in that bill of review case, the judge then sets aside the judgment, and then the underlying case reopens. It doesn't mean it goes away. It just means the judgment is lifted, the underlying case is there, and then you can fight the underlying case. Now, one caveat is, when I said it's 4 years, normally it's 4 years, but if you don't know about it for a while, then that 4 years won't start until you discover it. So I've had some cases where my client didn't find out about it until after the 4-year limitation period was up, but they went to go apply for a loan, or they went to go sell a house or something, and that came up. And so from that point on, they got 4 years. Quite frankly, it's not a good idea to wait another 4 years once you find out. So if you're past the statute of limitations, the law says they want you to really act with due diligence to get, your dispute on record as quickly as possible.
Can a debt collector ask you to verify your information, social security number, address, but don't tell you the information to verify they want you to give them the information? So
a lot of times what we'll see that the question is can a debt collector ask you to verify information without giving you any information? And then you will see that debt collectors will say, well, before we can talk to you about this debt, we need to verify so and so and so to make sure that you are who we think you are. That is really just a trick, because they're just trying to get information out of you. No, they're calling you, so they should identify you. They should identify themselves. In other words, you don't need to say, well, okay, well, my last four, my social security number is blah, 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 and my birthday is blah, blah, blah. And then they're like, okay, well, now that we've verified you, all they've done is they've got information that they may not have had before. So when they ask you for that information, don't have to argue with them. You can just say, I'm not going to provide that information. And remember, you're the reporter, and you're going to frustrate a lot of debt collectors when you become a reporter on a debt collection call, because that's not what they want to do. They want to interrogate you, grill you, and get you to pay. You want to slow down the call, ask them questions. it's funny, I've seen some, if maybe some of y'all don't do this, but I've seen some YouTube videos where people have fun with debt collectors, right? And they will keep them on the phone for an hour, just trying to mess with them and ask them questions and all this. And then finally, the debt collector gets frustrated and hangs up because they've lost an hour of call time they could have been using to call someone else. So you're the reporter, don't answer their questions, don't identify stuff that they're not telling you. They can say, well, we have your birth date is such and such and such, and you can agree to that, but you don't need to give them your birth date or your social.
This one, I don't think really regards to debt defense, but I will ask it anyways. Can eviction notice service be done by email or regular non-registered mail in Texas?
So this is, evictions are a separate breed from debt. We understand that the unpaid rent is considered debt, but evictions do have their own laws. The question is about the form of the eviction notice. I presume it's the notice to vacate. The law has certain requirements for how the notice to vacate should be handled, right? So it's either in person or it's on the front. If you're in an apartment, it's on the inside of the front door. They can also mail it to you by certified mail. Normally, email is not a legal method to do it. Now, some people may bootstrap what they do with emails, but email can't be the thing that they say is how they gave you notice.
I have one more. When being sued for a debt, can you be served at a random location or does it have to be at your house?
So the question is when you're sued for a debt, do you have to be served at your home or can it be basically anywhere? This applies to all cases, not just debt cases. A constable or a private process server, as long as they find you, they can serve you. They're not restricted to only serving you at your house. Now, we know that the citation is usually issued with the home address on there because that's what they know. But the law says that you can be served wherever you may be found. So if a private process server is following you or figures out where you're at, can they go up to you at a restaurant and serve you while you're eating a meal? Yes. Can they, you're stopped at a stoplight with your window open. Can they throw it in your car? Yes. And furthermore, you are, the law doesn't say that you have to take it or do you have to sign for it. So all the process server or constable has to do is to make sure that they've given it to you, because if it were the case, otherwise, you could just say, I'm not taking it and never take it. And then you never be served. So some people think that you have to sign for something or that you have to physically take it. I was at a deposition this past week where my client in the middle of the deposition during a break was being served by a private process server with a subpoena for a hearing. And as I was walking next to him, private process server came up and I turned my client around. I told the process server, we're not doing this. We're not taking that right now. We're in the middle of a deposition, walked away. Of course, the opposing counsel and I got into a little argument about on the record about whether that was a fair thing to do because we're actually having an attorney-client meeting and you can't do that. But technically my client was served even though we didn't take it. So all he did was leave it on the front desk. And then when we left, we took it. But that's how service is. So yes, they can serve you anywhere they can find you. And I think that's the time we have. We're a little bit over. Again, we're going to try to be doing these each month. It's going to be the second Saturday of each month. It's our Sanchez Law Firm series. I thought I was going to call it consumer law series, but we do more than consumer law. We do a lot of real estate litigation. That's not necessarily consumer law. So, but every second Saturday, we're going to have a seminar where we invite people, so many people to come in person. We have about 20 seats here. And then we also are going to have a lot of people by Zoom. And so we do appreciate you. Again, next month is going to be consumer auto fraud on November 11th. And then in December, we will do landlord tenant law. Thank you, and y'all have a great weekend. Thank you for coming.